Good afternoon and welcome to the September 22nd Civil Service Commission meeting. May we have a roll call, please?
Commissioner Devine?
He's present. I believe he's elsewhere.
Commissioner Gregorian?
Here.
Commissioner Gantis?
I'm here.
Commissioner Manukian?
Here. Okay, what's next?
Minutes?
I won't read these because I wait for Commissioner Devine. Here he is.
Okay, Commissioner Devine.
Is here.
Commissioner Devine has arrived.
Okay.
1 minute after John Gantis. May the record reflect
that's
that.
bad.
Don't go
Starting a
there.
new act here.
Okay, gentlemen, what's your pleasure? Have you had an opportunity to look at the minutes? Do I have a motion?
Make a
Do we have a
motion.
motion? Do we have a second?
Second.
May we have roll call, please?
Commissioner Devine?
Yes.
Commissioner Gregorian?
Yes.
Commissioner Gantis?
Yes.
Manukian?
Yes. What's next?
Oral communications?
Okay. Oral communication. Discussion is limited to items not a part of this agenda. Each speaker is limited to 5 minutes. Commission may question the speaker, but there will be no debate or decision. I see no cards. Anyone in the audience wishes to speak? I see none. What's next?
Eligible list established.
Mr. Doyle.
Mr. Chair, members of the Commission, this item represents the eligible lists that have been established since our last meeting. As you can see from the report, there have been 4 lists, 1 open list, and the remaining 3 are promotional. The report is prepared showing the name of the exam, the total number of applications received, and in the far right column, the total number of individuals who made it onto the eligible list. If you have any questions about any of these exams, I'd be happy to try and answer them. So,
Okay. Any questions? I see none. What's next?
Class specification for approval, Director of Community Services and Parks, and Assistant Director of Community Services and Parks.
Mr. Doyle.
Mr. Chair, members of the Commission, this is the specifications for approval, 2 new classifications that have been established as a result of a realignment involving some various departments of the city. One is for the department head position, Director of Community Services and Parks, and the second is for the number 2 position in that department, Assistant Director of Community Services and Parks. As you well know, there was a significant realignment of several city departments earlier this year. The department formerly known as Community Development and Housing was reorganized, and its various functions were reassigned and absorbed by 3 existing city departments. Our Parks Department picked up a few pieces, the Planning Department picked up some, and Development Services picked up others. The specification tonight relates to what is now what was formerly known as the Parks, Recreation, and Community Services Department, which is now called Community Services and Parks. I hope that's not confusing, but the Community Services and Parks Department picked up a couple of programs, the Community Development Block Grant Program, Workforce Investment Act Program, homeless programs, and various other programs that focus on more of a broad-based human service orientation, and it's more or less changed the flavor of that department, which had traditionally been a Parks and Rec type department. So anyway, the changes you can see from these new specifications are really reflective of the changes within that department. So had a chance to review the specifications. They are here for your review and approval. We have Ms. Beers from the City Manager's Office. Have any questions for her? And Mr. Chapchian, who is the Director of Community Services and Parks, is here as well, along with Steve Nersessian from my staff, who worked on these specifications. And I don't want to leave out a very important person out there, Mr. Jess Duran, who is the Assistant Director of this department. So if you have questions, I'd be happy to try and answer them.
Commissioner Devine.
I have 2 quick questions. Number 1, under education and training for the director, they use the term, actually this is the assistant director position, they use the term, one of the qualifications or training is urban planning, and they don't have that under the director education and training. They just have planning. I don't know whether it's it means the same or it's not important, but I think both should be parallel or identical. So I would just suggest plugging the word urban into planning on that one.
Actually, Mr. Devine, to be perfectly correct, it was city or urban.
Pardon me?
It says city or urban planning.
You're correct, yes. The second question I have,
And I agree with you.
okay, thank you. The second question I have is, with these new specs, would this include all of the eligible people from all of the departments that were folded into the community parks and whatever we call it?
Community services and
Community
parks.
services and parks, I'll have to learn that one. So my concern is that if another department was folded into that department, and there are people at certain levels, would they be eligible to apply for the director and assistant director positions, or would there need to be additional qualifications or training in there?
Mr. Chair, Commissioner Devine, I do believe the way this has been written that it would encompass all of the people that have been added. And a perfect example of that is Mr. Duran, who was the Assistant Director for Community Development and Housing. So I think if you look at the experience requirements and educational requirements, it is sufficiently broad enough to cover a variety of different disciplines. I mean, just looking at the education alone for the director position, you have a degree in parks administration, recreation, architecture, planning, sociology, social work, public administration, or a related field. I think that just about covers anybody who would work in this field.
Or come from another department?
Yes,
Thank
very
you.
much so. And on a second point, I do agree with you on the inclusion of the city or urban planning in the department head specification. That was probably just an oversight. There ought not be any significant difference between the minimum requirements for both of these positions. So.
Thank you.
I don't.
Any other questions?
No, just another question, but I don't see any misunderstanding or problem here. I mean, it covers everything. So, I don't know, in special reason that Commissioner Devine is asking for
No,
this...
what he's
just
trying to
the
do
one-
is make both of them reflect the same requirements.
Because generally speaking, architecture, if somebody has some background in architectural education, definitely there are some city and urban planning under that.
Not necessarily.
It does.
Yeah, but it should still be the same. But I understand what Mr. Devine is saying. What they're doing is basically trying to match both requirements.
So practically, what you like to say that on this, you would like to see that city or urban planning added to this planning category over here. Is that correct?
That's correct.
Correct.
Directors.
To the director's position. Any other questions?
I have a comment, Mr.
Please, Mr. Gantis, we'd like to hear your
Now that
comments.
Mr. Duran has moved over to the, first of all, George and Jess, I see now that Parks is more than Jungle Gym. We have more under Parks than worrying about the parks. But Mr. Duran, your new hairstyle, you look great in the new department.
Is that part of the requirement?
I don't know. I'm just commenting. That's you. I don't know if that's good or bad. We'll probably leave that.
Okay.
Okay.
I'm done.
Getting back to the subject.
approval.
Do we have a second?
Second, yes.
Move
As
to
amended.
approve as amended, correct?
As amended.
Second. Do we have roll call?
Commissioner Devine?
Yes.
Commissioner Gregorian?
Yes.
Commissioner Gantis?
Yes.
Commissioner Manukian?
Yes. What's next?
Civil Service Rule Amendments.
Mr. Doyle. I'm scared to say it. It's yours.
Okay. Mr. Chair, members of the Commission, this does represent effort to amend our civil service rules. It's the first time we've done this in about 5 years. We did a wholesale review in 2005. This represents a culmination of probably over 2 years of work, and not that we've been working on this project continuously over the past 2 years, but we have had various ideas, suggestions, and things that have come forth that we feel we'd like to present as far as making these rules better, new and improved, and that would help us do our job a bit easier. Really, there are several objectives contained within this. Really, I would narrow them down into 3 broad categories. One, making sure that these rules are contemporary and meet the latest as far as federal and state law in various areas that they touch. 2, that they contain various efficiencies and improvements on the way we do our job and the things which govern the way we do our work, whether it involves examination, processing, recruitment, all the things that are governed under civil service. Keeping in mind that under civil service, efficiency is not necessarily the primary objective. The protection of employee rights, applicant rights, and the betterment of promotion of the merit system remains some of the primary concerns. But we do want to make sure these rules do provide for the most effective and efficient manner of handling our job. The third broad category, I would say, relates to just providing some clarity in some of the areas. And I think you'll see as we go through some of these rule amendments, the idea is very clear as to remove anything that might be contradictory, confusing, or just plain difficult to understand. Many of these rules go back several years, and each time we amend them, we try to pick up things that need improvement or clarification. We don't always catch them, but I think you'll see a few examples as we present here of things that are really designed to improve the clarity and understanding of this particular document. As you know, back in February is when the Commission first got an introduction of these proposed amendments. At that time, approximately 28 were presented before the Commission for a very preliminary review. And it was at that point that the Commission did give direction to staff on which amendments to pursue, as opposed to those that were not recommended. We received direction to not proceed with 5 proposed amendments, so those were dropped. And at that time, one amendment that was proposed required further legal opinion. And that, in fact, has since occurred since that meeting, obviously. In fact, a copy of that legal opinion on that particular subject is attached as Exhibit 3. In addition to that, staff was directed to more or less finalize the list of proposed amendments, consult further with our employee associations, and prepare for this meeting. So essentially, we're at the point where we're ready to bring these back to you. In addition to those that we had talked about back in February, one additional amendment was proposed, which I think you're all aware of. This occurred at the August 25th meeting involving a change to our process for reinstatement. And that item was passed, and it was recommended that it be brought and included within these proposed amendments. So with that, I do want to present these to you, and again, we can go through these one by one or in blocks, or if you want to pick and choose some, that's up to you. I do just want to go over for the record. Exhibit 1 represents a pretty exhaustive summary of each individual rule change. Exhibit 2 is the document itself with the added language underlined. Anything that was removed is stricken. And then Exhibit 3 is that legal opinion on the one item relating to hearings, which had review by the city attorney.
Mr. Doyle, I had a quick question in the process of how we go about doing this, and it's more of a question. Since we've already gone through a majority of the stuff that we've reviewed, I don't know how my fellow commissioners would like to do this, but could we possibly start, the ones that we're all in agreement on, do we need to still go through them? Or can we just start going over the ones that my fellow commissioners have questions on? It's just a question.
I might defer that to Mr. Howard, but this is part of all of these are part of the record, and
Yeah.
you can simply, if you want to approve all of them, or the odd-numbered ones, or whatever, that can be done. But we're happy to go through in
It's
whatever
just in the
detail.
interest of time, because we've gone through
Certainly.
this several times, some of the items that I see, they're identical to, so Mr. Howard?
And Mr. Chairman, members of the commission, it is not a legal issue. It really is within the pleasure of the commissioners to determine how you want to approach this, whether it's each individual item, or you want to do it, as Mr. Doyle indicated, either in blocks, or just start going through and ask, maybe you want to go through each one. Is there any questions, any concerns? Go to the next one and continue to rapid fire until you hit one where there's questions, concerns, or other issues.
Okay. That's, how does the commission feel? You guys okay with
I'm
that?
prepared to make a motion, Mr. Chairman, to
Okay.
adopt in Exhibit 1
Okay.
those changes numbered 1 through 21.
Okay.
Those were ones that we've looked at, and you're right, they've been ad nauseum.
1 through 21?
Yes.
Okay. Does anybody have a problem with that?
You need to have a second on the motion.
I would second that.
Okay. Can we have a roll call, please?
Commissioner Devine,
Yes.
Commissioner Gregorian,
Yes.
Commissioner Gantis,
Yes,
Menuchyan.
Yes. So we have left 22 and 23.
Mr. Chairman, if I may, on number 22, I'm prepared to move to accept that. However, a question occurred to me, and I think it's covered, I just couldn't find it. 22 talks about the fact that upon resignation that the employee not leave the employment of the city before accepting the second employment. A concomitant question I would have, do the rules provide a provision where an employee may be on stay-at-home administrative leave, or basically that there is some method that says that they cannot be employed, and a method that if it does happen, there is some penalty and or ability for the city to recompense itself for double payments.
Mr. Chair, Commissioner Gantis, I think what you're asking is if an employee is on administrative leave, essentially, are there policies that would prevent them from holding outside employment
It's
while they're on
yes,
administrative
plus.
leave employed by the city of Glendale?
Yeah, basically, if an employee is on administrative leave such that they're assigned home duty, they're home, they're on administrative leave with pay, are there policies that prohibit them from working elsewhere, and or at least not being in their job at home on their 8 hours? And is there a methodology for the city to recompense itself if in fact that employee is found to have worked?
Members of the commission, the answer to the first question is yes.
Is it in these rules?
It is not within the rules. However, when an employee is placed on an administrative leave, they are sent a letter, and the ordered leave is provided for under Rule 10 of these rules. But that letter typically states that that employee is required to stay at home and that they're assigned to their home for the duration of their normal work hours. So if an employee does go out and find another job, they would essentially be violating that order, and thus they'd be subject to disciplinary action and removal. Secondarily, there is a administrative policy in the city relating to outside employment, and it applies to every single city employer, I should say every single salaried employee of the city of Glendale, which prohibits them from holding outside employment unless they get approval, specific approval from the department head to hold that outside employment. So in that circumstance, for somebody on an administrative leave, if they go out and obtain some other job, they would in fact be in violation of that policy, unless for some unusual reason the department head would have granted them the ability to go out and hold a secondary job. But as far as that is concerned, I think city policies do cover that.
Second part, I'm
The
sorry.
second part about compensating, I'll let Mr. Howard answer that, because I don't believe there's a way of doing that.
Mr. Chairman, members of the Commission, the Department of Labor rules in this state prohibit you from exercising what we call self-help. In other words, if we determine that an employee is in violation of one of our rules or regulations and either was paid in error or even falsified records and obtained payment, or had a secondary job and was obtaining compensation for that inconsistent with our rules and regulations and policies, we could not deduct money from a check, for example, to recompensate ourselves. We would have to institute legal action.
And that's my question. I know that, but
We have
the ability to do that based on our rules now.
You don't need the rules to do that.
Okay.
And we've actually had a couple of cases where we've contemplated doing that, and it involves not only certainly the legal process in which we look at, but also there's policy considerations. That's why for me or my staff to institute legal action, we need City Council approval.
So if, in fact, we discover that an employee who is placed on administrative leave with pay, assigned to their home for all intents and purposes, instead gets a job and is compensated, that violates the administrative policy, which are grounds for termination or any other discipline. But in addition, we'd have the ability to file an independent lawsuit against that person for recovery of the wages if that's outside of that policy. Is that correct?
Mr. Chairman, members of the Commission, Commissioner Gaddis, the short answer is yes. Depending on the facts and circumstances, there could also be a crime involved, a misappropriation of public funds.
We've seen that in the last few days, haven't we?
Well, yeah. We've seen allegations of that. We haven't seen anyone convicted. But there have been cases, published appellate decisions, where individuals who have signed claiming that they're out on sick leave and that they were actually holding another job have been charged with and convicted of a misdemeanor.
I would move, Mr. Chairman, that we accept Rule 22. The revision proposed in Exhibit Number 1 as item number 22.
Second?
Can we have a roll call, please?
Commissioner Devine?
Yes.
Gregorian?
Yes.
Antis?
Yes.
Menuchyan?
Yes. Okay, so we have item number 23. Mr. Gantis?
Mr. Chairman, item number 23 is the proposal raised by Commissioner Devine regarding the elimination, if you will, of this commission oversight of reinstatement of employees. First, before let me just say that I will not support this a rule amendment, but before I do that, I want to start on a positive note, and I mean that sincerely. This is probably going back to the days that before Mr. Howard was born that this thing was put on the list, and if it was before Mr. Howard, it was before me, probably. It's that old. Yeah. And that I'm not sure any of us has ever really focused on the issue of reinstatement. I think, given the fact, and just for the public's knowledge, what we're talking about is an employee who, for various good faith reasons, or a reason or reasons, decides that they no longer wish to work for the City of Glendale and have tendered a resignation, and within a period after the 90-day period of resignation, but before 1 year, has applied to be reinstated as an employee in the City of Glendale. And those matters would initially be through an application process through the appointing authority, the department, if you will, approved by, I believe, the appointing authority and the city manager, but ultimately the final approval under the old rules or under the existing rules would be with the commission. Mr. Devine quite rightly has pointed out that while we don't get a lot of these, they're generally perfunctory because basically we see the application and we're not rehiring anybody. I think the important thing is that everybody understand we don't get to hire them. They are placed on what is known as a reinstatement list. Reinstatement list is a list that the appointing authority can get to under certain priorities to rehire that person if a vacancy occurs for which that person is eligible. While Mr. Devine, and this has caused me to really reassess this entire issue and think about it, because it has been perfunctory. Many things in civil services, I know Mr. Howard will attest to, and Mr. Doyle have been here long enough to know that, and I've now been here long enough to attest to that, and in civil service are somewhat perfunctory because they've been going on for years and years and years and haven't been looked at. I appreciate the opportunity to look at that. Nonetheless, what this rule proposes is that the Commission lessen its oversight over an area of the civil service. And in today's market, if you will, in today's society, I cannot support anything that I think lessens the oversight that we as representatives of the public would have on anything. Now, Mr. Devine's correct. We've never, that I know of, turned down a reinstatement request. However, the very fact that it has to come to the Commission, which means that all the I's have to be dotted and all the T's have to be crossed, and for the most part, the employee appears in front of the Commission, and thanks to the initiation of former Commissioner Albert Epkarian, we always ask now the same question, and that is, why do you want to return to the city of Glendale? And we get a response as to why that employee wants to be in the city of Glendale. I think that we are exercising a discretion on behalf of the public that the public has a right to know. Public doesn't hear this, by the way, members of the public. This is all done in closed session because it's a personnel matter. You don't know who that employee is. But we represent the public. And given the fact that we represent the public, by and through the City Council, who does not, as all of you do know, has very, very limited input into the civil service process under our charter, I think that we would be abrogating a responsibility that may not have been something that we've seen in the past, but given the incredible microscope under which I think public employment is now being looked at and will probably be looked at in the future, I think for us to say that we're not going to exercise even the most perfunctory issue as looking at somebody that wishes to be reinstated, I think this is not a good precedent to set, and it is not something that I feel I can support in this matter. So I am not supportive of this change in item number 23 of Exhibit 1.
Mr. Devine, I'd like to hear your point of view.
I'd be glad to give that to you. First of all, I want to start out by saying that I absolutely respect and admire John Gaddis and his knowledge and skills in the civil service area. He's been a great mentor to me, and I think he has more knowledge than all of us put together. So I truly understand and respect the point of view he just expressed. I did have a conversation with him previous to this where he actually enumerated 5 items, some of which he addressed tonight, as to why he feels that this should not be approved. And I had a chance to think about them a little bit, and I've written out these statements so that I'm sure I cover all my thoughts on it. But the first thing he brought out to me is that, and he mentioned this tonight, he wants to be able to ask, why did you leave? Why do you want to come back? And will you stay? And my answer to that, or my thoughts on that, are these questions have already been asked and answered during the vetting and signing off process by the appointing authority, the Human Resources Department, and the City Manager's Office. Adding another level of Q&A, which is already provided by an exceptionally professional staff, is more than redundant and very unnecessary. It is not the Commission's responsibility to determine if an employee should or should not be placed on a reinstatement or any list. It is our duty to assure that all prospective and existing employees have an equal opportunity to apply for employment, and that the requirements for employment, i.e. the job specifications, are fair for everyone. This rule change allows us to do our job by including the provision that an employee has a right to appeal a denial decision to the Commission and thereby exercise his equal opportunity rights. Also, the applicants are not required to appear before the Commission. We have heard and approved several cases where only the applicant's representative and/or staff from the appointing authority appeared. In one case, the staff represented the applicant and offered to let the commission talk to the applicant by telephone, and we decided that that was not necessary. The second item he brought up was the loss of control and oversight of this process presents a higher risk than the risk of redundancy if the process is left in place. My response to that is there is no loss of control and oversight in regard to our required duties and responsibilities. We are required to assure that everyone has an equal opportunity for employment. Our control and oversight for this responsibility are maintained through the appeal process, which is included in the rule change. The third thing he mentioned was the workload of the commission is down. Therefore, the few reinstatement cases we hear would not create a burden on staff or the commission. My response is, it is true that the commission workload is very small and that the extra work of preparing reinstatement cases would not significantly impact the function of the staff or the commission at this time. However, it is questionable as to whether this is a valid reason for perpetuating a process that the staff and the majority of the commissioners have evaluated and determined was redundant and unnecessary, and that the city attorney has determined is not required by the city charter. The fourth point he made was, by the commission not having control over the entire reinstatement process, there is the potential for favorites to be brought back to the city and thereby possibly impair hiring or promotional opportunities of personnel on existing lists. My response is, when the commission considers the request, there is no way it can determine if an applicant is a favorite. There is no nexus between any of the questions of the commission that the commission may ask and the possibility that they are a favorite. While a potential for favoritism exists in any civil service system, the hierarchy of lists, that is, the layoff, the promotional and reinstatement, the open and open, and the rule of three provides much more control over the ability of the appointing authority to pick up reinstatement favorites than the redundant rubber stamp process now in place with the commission. And finally, he mentioned to me and also tonight is we need to protect the public when evaluating reinstatement requests. And in my reading of the charter, I found that nothing in the charter gives the commission the duty, power, or authority to provide protection for the public in creating rules or making civil service decisions. Instead, the charter gives the commission the authority, power, and duty to protect the sanctity of the Civil Service Commission by assuring that employees are hired on merit rather than political patronage. It is the appointing authority that has the duty and responsibility to protect the public by hiring the most qualified candidates, regardless of whether they come from a promotional, reinstatement, or open list. So that is my response. And again, I respect what Mr. Ganis has said, but I, as you can see, have a different view on this.
I understand. We respect that. Mr. Gregorian.
Well, I believe that we don't have and this commission doesn't have any right on anything, hiring, firing, anything. The only thing we do just to listen. Is that correct? I mean,
We don't hire and fire, but we do. Mr. Devine's correct.
Disciplinary action over here. That's part of our job that we are doing over here as a commissioner. So, still, again, I'm going in both ways. You know, Commissioner Devine has some points. In the meantime, Commissioner Gantes has some points too, because it's very difficult to exactly point which part of it is right, which part of it is wrong. So, in a way, you know, I'm thinking the other side of the scale. I agree with Mr. Commissioner Gantes, but whenever I heard your explanation, I agree with you too. So, because it's very close. It's very close. I mean, it's not that we are not trying to. We're trying to create an environment that whoever has a point, he wants to come back, try to listen to him. That we did a few weeks ago. We had a case that we had to listen to all the argument.
So
basically, I would like to see, I mean, a little bit more concise.
I hear what you're saying.
Yeah.
To be honest with you,
what's your feeling, Commissioner Chair?
I can't believe that I'm about to say this, but I agree with John. I mean, this is the first, John.
I know.
I give it to you. It's the first time.
I'm marking it down.
Please. But I do have to agree with Mr. Gantis. But I do see Commissioner Devine's point, but I can't even believe I'm saying this. Yeah.
But nobody's perfect, nobody.
No, but I do agree with both of my colleagues, but I think Mr. Gantis sold me on, you guys should be good politicians. Anyways, do I have a motion?
Well, what is the motion? Let's clarify the motion.
You have to move to, probably need, if I'm correct, Mr. Howard, a motion
As
to
is.
accept number 23,
Or
if
there
there's
can
no
be
motion, then it dies for lack.
That would be an affirmative motion to move the item onto the floor for a vote. However, if a commissioner feels strongly enough and wants to get in a motion to reject it, that also would be in order.
Could you repeat that, please?
Either motion is okay.
Either motion, a motion to affirmatively adopt this rule, which would then move it, would open it up for a second. If it got a second, it would move to the floor for a vote. If it didn't get a second, it would die for lack of a second. Otherwise, an alternate motion could be made if someone wants to make it to reject the proposed rule at item number 23.
I move to adopt item 23.
It's the rule at item 23.
Do I have a second? I hear none. Do I have another motion?
Actually, the motion dies for lack of a second. You do not need another motion.
Okay. So, do we still need a motion to approve the item because that item wasn't approved?
No, that motion to adopt the change to Rule 10, Section 5 at item number 23 has been rejected. What will now go before the City Council is rule or items 1 through 22 that have been adopted by the Commission, and staff will probably note in the report that a proposed Rule 23 was moved but did not receive a second.
Okay.
And Mr. Chair?
Yes, sir?
There was one other item that was on the proposed rule change, and Mr. Howard was doing some research on it. It was another idea that I had, which was to whether or not we need to have a full commission make a decision on disciplinary hearings, whether the three of us as a panel could do it or whether it required the whole commission. Mr. Howard did a lot of research on that, and he's come up with the answer on that, and the fact that it's not in the package obviously means that it was not allowed by the city charter. It takes the whole commission. I did ask one other question, though, as to whether or not if we have the whole commission and we're acting on a disciplinary action and one or two of the commission members are absent, whether we had to wait for everybody to come back or whether those 3 or 4 people could act on it. And I believe Mr. Howard has an answer to that.
Now, is that during the hearing process?
This would be during the deliberations
Okay.
when we either adopt or reject the decision of the disciplinary action.
Okay.
Mr. Chairman, members of the Commission, quick background. The opinion you have at Exhibit 3 differentiates between the ability for a single hearing officer or a lesser number than the full commission to actually hold the hearing. What the charter commands, based upon not only the language of the charter, but also through the ballot arguments that I've interpreted and very similar language found under the state personnel board system, is that the full commission has to make the decision after receiving a referral from either a single hearing officer or a limited number of commissioners who are sitting as hearing officers. As a result, as Commissioner Devine noted, he asked another question, and that is what happens if you have as you do right now, you have a vacancy. Under those circumstances, and I'm going to answer the question in different subparts. Subpart 1, with that example, this commission right now is considered a full commission. Having a vacancy, this is a full commission. Subpart 2 is if you have an absence. If you have a temporary absence, that is not considered a full commission. So a temporary absence would preclude a decision on a disciplinary matter that's brought from a hearing officer to you. However, that would potentially compel the matter to get put over to the next agenda item when you have a quote-unquote full commission. However, parties are allowed to waive rights. They are allowed to waive, and they do it many times. They waive constitutional rights, they waive statutory rights, as long as that waiver is not against public policy. I've done some research and pulled up a few cases in the civil service context, and in my view, based upon my research, it is fairly clear, that a party can knowingly and intelligently waive the right to have a full commission make a determination on or decision on a disciplinary matter. Now, that would entail I wouldn't suggest that as a practice, by the way. You don't want the exception to swallow the rule. The rule should be that the full commission makes the decision, and I think there's reasons for that. However, should you have an absence, and should the parties, you can certainly make the offer that the matter is going to have to go over 2 weeks or 4 weeks or whenever the next time you anticipate having a full commission. You can request from both parties, represent the appointing authority, usually through a representative, and the employee. And the employee with a representative, both can knowingly, intelligently, voluntarily waive the right to have the full commission make the decision. And I would suggest that you get that on the record by both sides, and at that point in time, when you have that waiver, the courts are very clear. They've allowed the waiver of time and a half salary, for example, even though there's a strong public policy in favor of it.
Does the waiver have to come from both sides?
Yes.
Okay, so it has to be from both sides, has to agree to it. All right.
Yes. And again, whoever's here advising you can assist you with that, but it's a very straightforward process.
Okay.
But as Commissioner Gandis knows in his other life, individuals waive constitutional rights to trial by jury, cross-examination, and the like. Statutory waivers occur quite frequently by stipulation or otherwise. This is one of those rights that from my research, is waiving it would not be a violation of public policy. In fact, the right to have a full commission seems to run in favor of the employee, so that the full body is there making the decision. And if the employee knowingly, intelligently, and voluntarily, and that's really key, and the burden would be on the party who is essentially trying to assert the validity of the waiver later on, to make sure that there's enough information in the record so that a court reviewing that waiver can reflect on the voluntariness, the fact that it's knowing and intelligent. That's why I suggested both parties put it on the record, not being duress. It's not under a duress. It's there. They voluntarily do it. They have, with full knowledge of the consequences, and they move forward.
Okay.
Thank you. I'd like to personally thank, and on behalf of the Commission, Mr. Howard, for a lot of work he's done on putting this together. I know he had to go down in the dungeon of the City Hall with the cobwebs and spiders and look
Still
up.
see it in his hair.
Yeah, I see
what
it.
little hair he has left.
So again, Mr. Howard, thank you very, very much. I appreciate your work on that.
Thanks, Scott.
Absolutely. Thank you very much. Okay. Next item.
Agenda forecast.
Mr. Doyle.
Mr. Chair, and before we get on to the agenda forecast, I do want to remind you all that the next step in the amendment process for civil service rules would be to take it to the full City Council for a vote. The only way to amend these rules is for an affirmative vote of both this body and the City Council. So we anticipate doing that in the next few weeks, and I'll notify the Commission when that does occur in case you want to attend or watch from home. Okay, the item agenda forecast, we have upcoming meetings. Our next meeting, we anticipate having the Human Resources Annual Activity Report. In fact, it's nearly complete. Ms. Mallon from my staff has done a great job compiling all the statistical data from our office this past year. The next meeting after that, we anticipate having a budget advertising expenditure report. This would be the first quarter of the 10-11 fiscal year. And the first meeting in November, we anticipate a presentation on the role and function of the Civil Service Commission and employee rights under civil service per the request of the chair. Aside from that, we anticipate having other bulletins, specifications, and such in the next few meetings. So if you have any further questions on that, I'd be happy to try and answer them. If there's anything you want to add, please let me know. So thank you.
2 months.
What's next?
Reports and information.
I have none.
None. Okay. Next item, please.
Civil Service Commission and our staff comments.
Commissioner Gantis.
Mr. Chairman, Mr. Doyle, I'd like to inquire. We considered a matter in closed session a few months ago regarding a disciplinary action, and did we get a final? Did that go out in final as signed to the various parties that were required?
I think so.
Yes.
Okay. Has it been more than 30 days? But it's okay. I think as long as it's out, we know it's out.
I think I signed it like 2-3 weeks ago.
Okay, that's fine. We're okay with that.
Yeah, about
Okay,
3 weeks.
Thank you.
Yeah,
That's all I have.
I think we're right at the 30-day
Okay,
point.
that's good.
Any other comments? Okay, what's next?
No closed session, adjournment?
Move to adjourn.
We're adjourned.